This will be jury charge at 140 words per minute for 10 minutes. Ready? Ladies and gentlemen of the jury, you have heard all of the evidence. You have sat very patiently throughout the trial and listened to the attorneys, the court, and the witnesses. You have listened to the arguments, the colloquy, and the voir dire. You have witnessed the mechanics of a courtroom trial and how we operate the justice system in the United States. You have given your full attention to every aspect of this trial, and this is appreciated by all parties concerned with this case. We now come to that part of the trial where you will be instructed on the applicable law as it pertains to this case. As you know, the law that is applicable to each case differs according to the circumstances. I want to thank you for sitting attentively and listening to the facts. During the last few weeks, you have followed along patiently during the direct examination of each witness. You have also followed along patiently during the cross-examination of each witness. You have had an opportunity over the last few weeks to ponder and weigh the facts of the case. You have examined the evidence as it was presented to you in the courtroom. We have given you an opportunity to examine and view the exhibits. Both the plaintiff and the defendant at various times throughout the trial have had exhibits marked for identification. Both the plaintiff and the defendant have had exhibits received in evidence. Members of the jury, you have devoted your full attention to every aspect of this trial. Your close attention to every detail is what we are counting on in order for you to be able to make a decision based on the facts presented in this case. Each and every one of the details of the case is important. Their clarification and understanding may weigh heavily on the outcome of the lawsuit. No point is too minute for your consideration. Tomorrow I will read the jury instructions to you in open court at 9:30 a.m. in Department 82. Your attendance at that time is mandatory. Each of the alternate members of the jury will be expected to be present at that time too. The alternate members of the jury have sat patiently throughout the trial. Their attendance at these proceedings is appreciated. During your sequestration, you will have an opportunity to review these instructions. The court clerk will make them available to each of you in written format. If at the time they are read to you, you do not understand something, please raise your hand and let me know. If you come across an instruction while you are in the jury room that you do not understand, please instruct the foreman of the jury to contact the bailiff to inform me of any questions that you might have. Any questions regarding these instructions will be explained to you by the court. They should not be explained to you by other members of the jury. You should remember that these instructions are not subject to interpretation. They are specific in design and should be interpreted for the purpose for which they were written. These instructions are designed to provide the jury with a written guideline for decision-making in this case. Whether or not a defendant is found guilty or not guilty is dependent not only upon the facts, but also upon the law. As members of the jury, you have two duties to perform. The first duty is to determine from the evidence presented in this case what the facts are. You are to determine this only from the evidence that has been presented in this courtroom and from no other source. You are to determine this on an individual basis without the interference of outside opinions. You are not to guess or speculate or conjecture what the facts might be. You are to take them only from the evidence presented here in this courtroom during the last 4 weeks. The word fact means something that is proved directly or circumstantially from the evidence. As defined in Webster's New World Dictionary, a fact means the state of things as they are, something that is said to have occurred or something that is true. This definition gives you a broad description of what you may consider as the facts in this case. Your second duty in this trial is to apply the rules of law that I will give to you. You are to apply these rules of law as you describe them to be. Try to pay close attention and listen to the rules of law when they are explained to you. Once you have heard them and determined their applicability to this case, attempt to determine a fair verdict. A verdict can only be reached by you, the members of the jury. Your understanding of every facet of the case is important to both the defendant and the plaintiff. Tomorrow it will become my duty to introduce these instructions and explain to you the rules of law that apply to this case. At that time, I will instruct you as to how they are to be applied in evaluating the facts of this case. You must follow my instructions in this regard, members of the jury. If there are no questions from counsel or the jury members, we will adjourn court until tomorrow morning at 9:30 a.m. Certainly, everyone enjoys the opportunity for a brief respite. Ladies and gentlemen of the jury, we will now discuss the meaning of the word evidence. The official dictionary definition of evidence is as follows: something that tends to prove or has a ground for belief, something that is legally presented before a court, such as a statement of a witness or an objection which bears on or establishes the point in question. The court will instruct you that evidence is to be distinguished from testimony and from the burden of proof. The court's definition of evidence is to be distinguished from testimony and from the burden of proof. The court's definition of evidence applies the principles of law to the meaning of evidence. Evidence consists of the testimony of witnesses. Evidence may also consist of written or printed material, objects, or anything that is perceived by the senses that is offered to prove or to disprove the existence or non-existence of a fact. Evidence may be either direct or circumstantial. Direct evidence is evidence that directly proves the existence or non-existence of a fact without the necessity of an inference. The court will instruct you that no presumptions are necessary to prove direct evidence. Direct evidence has been presented in the case at hand. Direct evidence by itself, if found to be true, does establish a fact.